into this case that got dismissed. They dismissed it, saying I am a vexatious litigant.
Does that hurt your feelings?
I'm
I'm just kidding with you.
I'm gonna break it off in their ass. What I'm gonna do. But anyway, so um, you know, I've done this enough times. Like I'm currently in the Supreme Court, and oh, that reminds me. I don't think I've gone through this.
Can you do a criminal complaint against the guy that said he refused to do whatever it was?
Yeah, well, that's essentially what I did, and I sent a copy to Donald Trump.
Any response yet?
Well, here, I haven't gotten anything back yet. No, what I expect to happen. It's a notice of objection. Oh, to the fake waiver. Right here.
Nobody signed it.
So this is what I filed with the Supreme Court. Now, yeah, let's show this first of all. Okay, so I'll show you the waiver here in a minute. Matter of fact, maybe I'll show you the docketing letter. Because what happens when you file a petition, first of all, you have to understand how the Supreme Court works. It says right in their rules that they can turn away any case they want.
Isn't that awful nice of them? If they get to decide they're working for us.
It says right in the rules for the Supreme Court that they can turn away any case they want. Now, well, you got to understand, they get thousands of cases every year. If they had to accept them all, they would need way more people than they've got. And so what happens is, like this Northern District of Texas is under the Fifth Circuit. Okay, the Fifth Circuit. If you read the statutes and that how the federal courts are set up, each circuit has a judge on the Supreme Court that oversees the circuit. In other words, Samuel Alito is the judge that oversees the Fifth Circuit. Okay, so I think, and I don't know for sure, but I think that any case from the Fifth Circuit that goes to the Supreme Court, they take it to Samuel Alito. He looks at it and decides whether this is something the Supreme Court's interested in or not. Now, it might go to Roberts. I'm not sure, but it either goes to Alito or to Roberts. I'm not sure which one.
His staff looks over.
I'm sure they do.
He don't look it over.
The clerk, well, I bet he does.
Really?
I bet he does make the final decision.
Okay.
So anyways, if the case gets turned away by the Supreme Court, then what happens is it doesn't get docketed. Okay, it doesn't even get docketed, and the reason I know that is I know people that have had their cases turned away by the Supreme Court, and it didn't get docketed. Okay, now I got to tell you that this is the 6th time I've been to the Supreme Court, and I have docketing letters for every one of those cases. So they get thousands of cases every year. They say they get about 5,000 cases. And of those, they accept about 5%, which means what? About 250 cases, right? 5,000 cases, 1% of 5,000 is 50. right?
Right.
So then 5% is about 250 cases they accept every year. You know, that's what they say. They also say that if you're someone out there that has to hire a lawyer, that it's going to cost you $2 million to go to the Supreme Court.
Dang.
Now, I can tell you, I've been in there 6 times, and I haven't ever paid anywhere near that. Matter of fact, I don't even pay the filing fee. So, anyways, so this is the docketing letter that I got from the Supreme Court. Notice it's GlennWinningham. The petition for writ of certiorari in the above titled case is filed on November 17, 2025, and placed on the docket February 23, 2026 as 25-6877. The form is enclosed for notifying opposing counsel that the case was docketed. And here is the letter that I'm supposed to send them, which I did. Notice is hereby given pursuant to Rule 12.3 that a petition for writ of certiorari in the above entitled case was filed with the Supreme Court of the United States on November 17th, 2025, and placed on the docket February 26, 2026. Pursuant to Rule 15.3, the due date for a brief in opposition is Wednesday, March 25th. So they still have another, 7 days. If the due date is a Saturday, Sunday, okay. This is interesting. Beginning November 13, 2017, parties represented by counsel, that's not me, must submit filings through the Supreme Court's electronic filing system. So, and then it says paper remains the official form of filing, and electronic filing is in addition to the existing paper submission. So they must file something by paper and by electronic. I just sent it paper.
Because you're not in their network.
I'm not a liar.
Right.
And then here, this is interesting too. Unless the Solicitor General of the United States represents the respondent, a waiver form is enclosed and should be sent to the clerk only in the event you do not intend to file a response to the petition. Only counsel of record will receive notification of the court's action. And then this is the waiver. And notice there's no boxes on it. I'll show you the waivers they sent me. So this is the waiver, no boxes on it. Now,
what does that mean when you say there's no boxes?
well, I'll show you. When there's a box on it, anything inside the box takes it off the page. That's right. There's nothing there. Shoot, I haven't scanned up. I have the waiver for County of Montague. Look at this. This is the one for the State Bar of Texas. So let's compare. I think it's one they made up. This is the one for the State Bar of Texas. I'm just putting this on YouTube. But notice the boxes.
Yeah.
The boxes are all over it. I think it's a PDF fillable form. But there's boxes there. And the one from the County of Montague, same thing. It had boxes all over it.
What does that tell you?
Well, anything inside the box isn't there.
Right.
So, anyways, so that's the waiver that the State Bar of Texas filed. And this is my notice of objection to the fake waiver.
Was it signed?
What sign?
I didn't get to see it. On that waiver, the state board.
It was signed, yep.
Okay. A lot of times they use a rubber stamp.
I know. And this is why I'm objecting to the fake waiver that the Solicitor General filed, because it's not signed and it's not the form that they gave me. It's a completely different form. And so, but I didn't say that in my objection. But this is my notice of objection. Notice these are the Court of Appeals removed a bunch of people off the case. But they listed what happened is one of the complaints that the clerk had when I was sending, like I sent this back and forth to the Supreme Court probably about 5 or 6 times. And every time, you know, you had this box, you had to file 10 copies, an original and 10 copies. If you were to file, if I had paid the filing fee, then I would have had to file an original and 40 copies. And so the shipping bill alone would be a lot of money. You know what I mean?
Right.
And so, but as it was, I had to file an original and 10 copies, which and it went back and forth about 5 or 6 times. Now, I don't think the Supreme Court pays any postage with the post office, but I know I had to. And every time it was like about $60 every time. And I've been out of work since 2015. So I mean, that's a lot of money for me. And then plus I have to serve a copy on all the liars too. So it had cost me a couple $100 every time to send it back to the Supreme Court with the corrections that the clerk asked for, and then to send the liars a copy. So one of the complaints they had was, because I had listed everybody, and if you go back to, and I don't have it here, I don't think. No, I don't. I guess I haven't scanned that up yet. I probably haven't scanned that up yet. I'm kind of surprised. Anyways, so this is the notice of objection to the fake waiver. And I'll show you a copy of it. Well, actually, I could scroll it down. Right here's the fake waiver. There's no signature on it. The other ones were signed. And this is how they've dismissed them every time. Okay, this is the number 6 time I've been to the Supreme Court. Every time the Solicitor General has waived his right to respond, and every time then I get a letter from the clerk saying the case has been dismissed. And if you think about it, it's because there's no controversy. Okay, the Constitution says there has to be a controversy. So remember, I think I went through the letter that I sent Donald Trump. I sent Donald Trump a copy of the lawsuit and a short letter saying that please make sure the Solicitor General does not waive his right to respond. Well, this is what he did. And so that's why I filed and I sent Donald Trump a copy of this. So let's go through what I said. The petitioner here provides notice of objection to the fake waiver by the Solicitor General because it fails to be signed, and for the following reasons. Number 1, there's no signature on the waiver. Number 2, waiving the right to respond admits everything contained in the petition especially the 17 questions for review. Waiving the right to respond admits that the minor estate at 31 CFR 363.6 is an act of Congress respecting an establishmental religion in violation of Article 1 and Amendment, and the United States Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error of Congress, which is perjury of the Solicitor General's oath and treason to the Constitution. Waiving the right to respond admits that the 1871 Corporation at 16 Stat 419 is an act of Congress respecting an establishmental religion in violation of Article 1 and Amendment, and the United States Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error of Congress, which is perjury of the Solicitor General's oath and treason to the Constitution.
That's good. You got him.
I think I did.
And Bill Ellis is the one that brought that up.
That's Bill Ellis's fault. Yeah, it's all Bill's fault. Waiving the right to respond admits that the National Bar Foundation, Title 35 U.S.C. 70501 through 70512, and all its subsidiaries in the various states is an act of Congress respecting an establishment of religion in violation of Article 1 and Amendment, and the United States Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error of Congress, which is perjury of the Solicitor General's oath and treason to the Constitution.
That's really good. That's strong.
Waiving the right to respond admits that the National Bar Foundation, Title 35 U.S.C. 70501 through 70512, and all of its subsidiaries in the various states is a violation of the Article 1 of the Definitive Treaty of Peace of 1783, and the United States Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error of Congress, which is perjury of the Solicitor General's oath and treason to the Constitution. Waiving the right to respond admits that the minor estate, 31 CFR 363.6, is a violation of the organic law of the Declaration of Independence, 1776. He's combined with others who subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation for imposing taxes on us without our consent, which is referencing the Pope and his Sestique V Act of 1666 as the reason for the War of Independence, and the United States Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error, which is perjury of the Solicitor General's oath and treason to the Constitution.
Good.
Waiving the right to respond admits that it is an unconstitutional violation of Article 1, Section 8, Clause 17, to use the minor estate, 31 CFR 363.6, and the Commerce Clause, Article 1, Section 8, Clause 3, to convert the petitioner's land from the land of Texas into the foreign District of Columbia, in spite of the fact that there is no commercial activity involved, and the United States Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error, which is perjury of the Solicitor General's oath and treason to the Constitution. waiving the right to respond, admits that the judgment of the 97th District Court that makes the petitioner a minor estate, 31 CFR 363.6, is a bill of pains and penalties, violation of the Bills of Attainder clauses, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1, and the United States Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error, which is perjury of the Solicitor General's oath and treason to the Constitution. This is the first time I've done this, by the way. The other ones, I didn't know how to respond, so I didn't. So we'll see.
Yeah, I mean, right now, you're almost ready to do a knockout punch.
Waiving the right to respond admits that a judgment by the 97th District Court that makes the petitioner a minor estate, 31 CFR 363.6, by presuming incapacity without adjudication, is a denial of due process of law under Article 5 and Amendment, and a violation of the Equal Protection Clause, Article 4, Section 2, Clause 1, and the United States Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error, which is perjury of the Solicitor General's oath and treason to the Constitution. Waiving the right to respond admits that the judgment by the Northern District of Texas that makes the petitioner a minor estate, 31 CFR 363.6, is a bill of pains and penalties, violation of the Bills of Attainder clauses, Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1, and the United States Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error, which is perjury of the Solicitor General's oath and treason to the Constitution. Waiving the right to respond admits that a judgment by the Northern District of Texas that makes the petitioner a minor estate, 31 CFR 363.6, by presuming incapacity without adjudication, a denial of due process of law under Article 5 and Amendment, and a violation of the Equal Protection Clause, Article 4, Section 2, Clause 1, and the United States Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error, which is perjury of the Solicitor General's oath and treason to the Constitution. Waiving the right to respond admits that the refusal by the Federal Bureau of Investigation to investigate the 78 criminal complaints is a denial of due process of law under Article 5 and Amendment, and the U.S. Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error, which is perjury of the Solicitor General's oath and treason to the Constitution. See, what I did is I just took the 17 questions and I admitted them all. Waiving the right to respond admits that the refusal by the Federal Bureau of Investigation to investigate the 78 criminal complaints is a violation of the Equal Protection Clause, Article 4, Section 2, Clause 1, and the United States Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error, which is perjury of the Solicitor General's oath and treason to the Constitution. Waiving the right to respond admits that the refusal by the U.S. Attorney to prosecute the 78 criminal complaints, a denial of due process of law under Article 5 and Amendment, and a violation of the Equal Protection Clause, Article 4, Section 2, Clause 1, and the United States Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error, which is perjury of the Solicitor General's oath and treason to the Constitution. Waiving the right to respond admits that an unconstitutional violation of the Equal Protection, that it is an unconstitutional violation of the Equal Protection Clause, Article 4, Section 2, Clause 1, for the bar member controller of Texas to authorize the County of Montague Municipal Corporation to make the petitioner a minor estate, 31 CFR 363.6, to render by force the petitioner's land for taxation, to justify the theft of the petitioner's land, to extort fake money in support of their communist agenda, to eliminate private property rights, and because the petitioner is a targeted individual, as evidenced by the targetedjustice.com website, and the United States Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error, which is perjury of the Solicitor General's oath and treason to the Constitution. Waiving the right to respond admits that the forced rendition of the petitioner's land for taxation by the County of Montague Municipal Corporation in conspiracy with the bar member controller of Texas in violation of the organic law of the Declaration of Independence, quote, he's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation, quote, for imposing taxes on us without our consent, which is referencing the Pope and the Sestakv Act of 1666 as the reason for the War of Independence, and the United States Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error, which is perjury of the Solicitor General's oath and treason to the Constitution. Waiving the right to respond admits that the findings, conclusions, and recommendation of the United States Magistrate Judge, which fails to be a findings of fact and conclusions of law, is a legislative usurpation of the bench because it's involving a fiction of law which fails to exist under the Pope's ecclesiastical law penalizing the petitioner, a named individual, with a non-judicial theft of land and a bill of pains and penalties violation of the Bills of Attainder clauses under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1, and the United States Solicitor General has... Are we talking or are you guys talking? And the United States Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error, which is perjury of the Solicitor General's oath and treason to the Constitution. Waiving the right to respond admits that the findings, conclusions, and recommendation of the United States Magistrate Judge, which fails to be a findings of fact and conclusions of law, is a violation of the Equal Protection Clause of the Article 4, Section 2, Clause 1, and a denial of due process of law, violation of Article 5 and Amendment by presuming incapacity without adjudication, and the United States Solicitor General has an oath of office requirement to support the Constitution, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court the right to correct the error, which is perjury of the Solicitor General's oath and treason to the Constitution. Waiving the right to respond admits that the 78 criminal complaints that the Federal Bureau of Investigation refused to investigate and the U.S. Attorney refused to prosecute are lawful, valid complaints, and the United States Solicitor General has an oath of office requirement to support the Constitution under Article 6, Clause 2 of this Constitution, and the laws of the United States which shall be made pursuant thereof shall be the supreme law of the land, which makes the Solicitor General an accomplice to the felonies after the fact, and the Solicitor General is denying the petitioner the right to redress of grievances guaranteed by Article 1 and Amendment, and denying the Supreme Court's right to correct the error, which is perjury of the Solicitor General's oath and treason to the Constitution. This is one I added on at the end, and I think this one is, I'll tell you, I think this one that'll get his ass arrested. Is what'll happen if I sent this to Trump. So here's
it's clear that he did treason.
well, absolutely.
There's no way around it. So if Trump wants to get involved,
I sent it to
he'll be
Donald Trump,
arrested.
and I sent it to the Solicitor General, and so we'll see.
Yeah.
But
They got to realize they work for the people, and they don't get to decide what they want to do. So we got to hope Trump will get involved and stop this guy. You did a good job with that, Glenn. You got pretty much every angle.
You certainly did. I think that's deserves a round of
Yeah.
applause.
well, let's see. This is the USPS website. Oh, look at that. So it was supposed to get there today, and the post office is lousy at best, and so who knows when it'll get there. That's this document that I sent by certified mail. That's the tracking on it
Yeah, that's going
So-
where's that going? When you sent that one?
to the White House.
Okay, they probably have to go through it quite a few times.
Well, it might have to go through some security and stuff like that. I wouldn't be surprised, but they're saying that it was attempted. So I don't know what's going on, but 10:04 a.m. March 17th, which is this morning. So I don't know what's going on, but so at any rate, so that is the. Let's go back to here. Right. See what's saying on YouTube. Nothing. So anyways, so that is the response that I sent to the waiver. Now, what else were we going to talk about?
Glenn, tell them about the definitive treaty of peace and that connection that you made.
Well, that's interesting. All right.
Where Texas, and it was declared as a nation by Andrew Jackson. And
Yeah,
once
but
he
that's not to
declares
do
it-
with the definitive treaty of peace, Darren.
Okay. But we have never had a peace treaty since the Civil War, correct, Glenn?
Yeah, we were going to go through the challenge to the constitutionality of Texas joining the Union. That's where I was going to go with it. We can talk about that. Don't let me forget. I'll cover that here in a minute. But let's go through this. Notice the constitutional challenge. So there was a couple documents that I filed before the case got dismissed, and there was two notice of constitutional challenge. One was for Texas, and the other one was the minor estate. But the minor estate issue is now before the Supreme Court, so I'm debating about whether I want to bring that up or not. But certainly this whether Texas joined the Union or not is a valid issue that I'm going to bring up with the Court of Appeals. So amended notice of constitutional challenge. Texas, pursuant to Rule 5, comes now demandants, providing notice to anyone interested that the demandant is challenging constitutionality of Texas joining the Union in 1845 as a violation of this Constitution of the United States of America, Article 4, Section 3, Clause 1, which requires, but no new state shall be formed or erected within the jurisdiction of any other state, which is what was done, as well as Article 6, Clause 2, the supreme law of the land, because the military occupation is a violation of Article 11 of the 1933 Montevideo Convention on the Rights and Duties of States, which requires that the territory of a state is inviolable and may not be the object of military occupation, which was ratified as a treaty and entered into force December 26, 1934 at 49 Stat 3097, as found in the brief attached hereto, all of which is incorporated herein by reference in its entirety. So under the local rules, okay, it's not the federal rules, but all the courts have local rules, and so you have to make up a document and then attach a brief to it with all the arguments that you're going to make. And so this is the brief, or this is a certificate of service. I didn't serve it on anybody because nobody had appeared yet. And so I just filed it with the court. Amended brief in support of notice of constitutional challenge, Texas, pursuant to Rule 5. President Andrew Jackson officially recognized the Republic of Texas March 3rd, 1837, which was also recognized by France December 25th, 1839, and other nations, including Belgium and United Kingdom, and the demand has visited the former embassy in the Republic of Texas in Paris, France, that is now being used as a hotel. The fact that the Republic of Texas existed is beyond dispute, and this is taken from the Law of Nations by Vattel, Book 1, Chapter 1, Section 1. If there's no definition of how many people, and there's no definition about how many people are required to constitute our nation or state. And this is Article 1 of the 1933 Montevideo Convention. The state is a person of international law, should possess the following qualifications: A, a permanent population; B, a defined territory; C, a government; and D, capacity to enter into relations with other states. And that's Article 1 of the 1933 Montevideo Convention on the Rights and Duties of States. That's why international relations there, Mr. President, is really important. That's why things like commissions and that kind of stuff is also really important. That's part of international relations. And all the inhabitants of the territory properly included within and rightfully belonging to the Republic of Texas are entitled to the same protection. And this is Article 9 of the Montevideo Convention. The jurisdiction of states within the limits of national territory applies to all the inhabitants. So we're talking the Republic of Texas. The Republic of Texas goes up to, Cheyenne, Wyoming is in the Republic of Texas. I don't know if you know that or not, but it is. Anyways, nationals and foreigners are under the same protection of the law, and the national authorities and foreigners may not claim rights other or more extensive than those of the nationals. And that's Article 9 of the Montevideo Convention. In the year 1845, the state of Texas joined the Confederacy and Union under Articles of Confederation and Perpetual Union, 1781, as evidenced by the Act of Congress at 9 Stat 1, and still exists as evidenced by House Joint Resolution 1, dated 29 December 1845. The territory properly included within and rightfully belonging to the Republic of Texas was erected into a new state to be called the state of Texas. It says right in there they violated the Constitution. On an equal footing with the original states and all states whatever, in all respects whatever, with the Republican form of government, as found in the Act of Congress, December 29, 1845. And so this is the preamble of the Act. At 9 Stat 1 says, be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled, that all the laws of the United States are hereby declared to extend to and over and to have full force and effect within the state of Texas, admitted at the present session of Congress into the Confederacy and Union of the United States. And in House Joint Resolution 1, dated 29 December 1845, 9 Stat 108, whereas the Congress of the United States, by joint resolution approved March 1st, 1845, did consent that the territory properly included within and rightfully belonging to the Republic of Texas might be erected into a new state to be called the state of Texas.
What?
Yeah.
That's a document that you wrote?
Yeah.
You mind emailing that to me at your convenience?
All of that stuff is in that latest declaration of peace that I sent you in WhatsApp.
All right, all right.
Matter of fact, I've changed the wording. There's some stuff that's been modified because there's stuff that I reconsidered. Let me put it that way.
All right. Yeah,
But the arguments and stuff are all in that
I remember. Yeah.
declaration of peace that I sent you, the latest one. I haven't sent that to anyone else either. So Misty was saying that they were working on something. Well, I don't know what they're working on, but I don't think they've got the latest one.
All right.
And then it says, resolved by the Senate and House of Representatives of the United States of America and Congress assembled that the state of Texas shall be one and is hereby declared to be one of the United States of America and admitted to the Union on an equal footing with the original states in all respects, whatever. That means the original 13. Because normally when one sovereign nation joins another sovereign nation, a treaty of annexation is done. A proposed treaty of annexation was prepared by the Republic of Texas and sent to the U.S. Senate for approval and adoption, which was not approved or adopted, but was shelved. The state of Texas was created under the Articles of Confederation and Perpetual Union, 1781, under Article 9. Canada ceding to this confederation and joining the measures of the United States shall be admitted into and entitled to all the advantages of this union, but no other colony shall be admitted into the same, unless such admission be agreed to by 9 states. Article 9 of the Articles of Confederation, 1781. Which means that House Joint Resolution is all that was needed. Therefore, the state of Texas is a fictitious overlay over the Republic of Texas. The territory properly included within and rightfully belonging to the Republic of Texas, which means the Republic of Texas was not replaced by the state of Texas. It wasn't dissolved. They couldn't. I don't think they could because the Republic of Texas is de jure. And the Republic of Texas still existed in abeyance, which is dormancy. Seems to the defendant that for the state of Texas to join the Confederacy under the Articles of Confederation of Perpetual Union, 1781, with the House Joint Resolution is perfectly fine, but the preamble of the Act of Congress, December 29, 1845, at 9 Stat 1, says Texas is admitted into the Confederacy and Union of the United States, which is also talking about the Union under the current Constitution, which was in place in 1845. And Article 4, Section 3, Clause 1 requires, but no new state shall be formed or erected within the jurisdiction of any other state, which is what was done. The state of Texas failed to replace the Republic of Texas, and the Republic of Texas, which was recognized by Andrew Jackson, still exists, and recognition is irrevocable, unconditional, and irrevocable under Article 6 of the Montevideo Convention on the Rights and Duties of States. That was acceded to by the U.S. Senate as a treaty and entered into force December 26, 1934, at 49 Stat 3097 as supreme law of the land under Article 6, Clause 2. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties which shall be made under authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. That's Article 6, Clause 2. And in the year 1861, the southern states, including Texas, walked out of Congress, and Congress ceased to have a quorum to conduct business and could not conduct business. On the 15th of April, 1861, Lincoln ordered Congress to reconvene under executive authority with Executive Order Number 1 at 12 Stat 1258. Notice the date. Interesting that that's tax day, and they've been operating under executive authority ever since. The southern states that walked out of Congress became the Confederate States of America, and the war between the states was started, which eventually ended with an armistice, ceasefire only. All of those people are now dead, but there has never been a treaty of peace. The state of Texas was one of the Confederate States of America. A technical state of war still exists between the United States and the Confederate States of America because there was no treaty of peace. But actually, in hindsight, and that's the reason I changed it, Lincoln invoked the Insurrection Act, so it was considered an insurrection. So there's no need for a treaty of peace, but we should still, as the Republic of Texas, reaffirm, get actually Donald Trump to reaffirm the recognition of the Republic of Texas, and we're peaceful and we're offering common law remedies. And the state of Texas is a military dictatorship set up by the U.S. Army and is completely incompetent to provide a Republican form of government. So we, the Republic of Texas, are the Republican form of government that's required. You see what I'm saying?
It's a good,
I agree, we can work on that, you and I.
that's really good angle he's got, because we're guaranteed a Republican form of government.
That's right.
And it's not here.
That's right.
Right,
And we look around and all these military police are everywhere.
right.
Just doing business.
The state of Texas. Okay, in the year 1863, Lincoln asked Harvard law professor Francis Lieber to write the law of war for the U.S. Army, which became known as the Lieber Code, which was actually designated General Orders 100, all of which is now included in the United States Law of War Manual, which is now a book about 4 inches thick and is part of international law, which is the law of nations. The current state of Texas is a military government put in place by the United States Army under Article 1, General Orders 100, the Lieber Code. A place, district, or country occupied by an enemy stands in consequence of the occupation under the martial law of the invading or occupying army, whether any proclamation declaring martial law or any public warning to the inhabitants has been issued or not. Martial law is the immediate and direct effect and consequence of occupation or conquest. The presence of a hostile army proclaims its martial law. The military government and martial law continues to this day under Article 2, General Orders 100, Lieber Code. Martial law does not cease during the hostile occupation except by special proclamation ordered by the Commander-in-Chief or by special mention in the Treaty of Peace concluding the war. Because there's been no special proclamations by the Commander-in-Chief, who's the President of the United States, and there's no Treaty of Peace to this date. Under House Joint Resolution 1, dated 29 December 1845 at 9 Stat 108, the state of Texas is required to have a Republican form of government. And it's impossible for a military government operating under martial law to be a Republican form of government because a military government is a dictatorship, as evidenced by Article 3, General Orders 100, the Lieber Code. Martial law in a hostile country consists in the suspension by the occupying military authority of the criminal and civil law and of the domestic administration and government in the occupied place or territory, and in the substitution of military rule and force for the same, as well as the dictation, as in dictatorship, as well as in the dictation of general laws, as far as military necessity requires this suspension, substitution, or dictation. The commander of the forces may proclaim that the administration of all civil and penal law shall continue either wholly or in part, as in times of peace, unless otherwise ordered by the military authority. So all laws in Texas are at the pleasure of a military authority. And because a Republican form of government requires law of the land, natural law and common law and political power be in the hands of we the people, and a symbolic military government called a democracy with all state of Texas employees, including all the wrongdoers named herein, being federal personnel as required by the Pope's Roman civil codes, 5 U.S.C. 552A 13, which is anyone with a social security number. Term federal personnel means officers and employees of the government of the United States, members of the uniformed services, including members of the reserve components, including individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States. For the Pope's 1871 municipal corporation, that's 16 Stat 419. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence which every particular nation, commonwealth, or city has established really peculiarly for itself, more properly called municipal law. So it's all really Roman law, and it comes from the Vatican. That exists today is the second national government talked about in the dissenting opinion of Downs versus Bidwell, and 182 U.S. 244, 1901, that is maintained by Congress outside and independently of that instrument, which is talking about the Constitution. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument, and that's dissenting opinion of Justice Marshall Harlan, Downs versus Bidwell. And is the Pope's military dictatorship plenary power because the boundaries of the District of Columbia expands for the purpose of regulating citizens wherever they go throughout the states of the Union. And this is National Mutual Insurance Company versus Tidewater Transfer Company, U.S. Supreme Court in 1948. And through their plenary power nationally covers those citizens, even in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. Therefore, the Pope's owned and operated United States has failed to provide a Republican form of government as required by Article 4, Section 4. The United States shall guarantee every state in this union a Republican form of government, except that the Republic of Texas is that Republican form of government. The military occupation is illegal under Article 11 of the 1933 Montevideo Convention on the Rights and Duties of States. Article 11, the contracting states definitely establish as a rule of their conduct the precise obligations not to recognize territorial acquisitions or special advantages which have been obtained by force, whether this consists in the employment of arms, in threatening diplomatic representations, or in any other effective coercive measure. The territory of a state is inviolable. The territory of a state is inviolable and may not be the object of a military occupation, nor other measures of force imposed by another state directly or indirectly, or for any motive whatever, even temporarily. So a military occupation is unconstitutional under the supreme law of the land and the 1933 Montevideo Convention, which requires that the territory of a state is inviolable and may not be the object of a military occupation, and because the 1933 Montevideo Convention on the Rights and Duties of States was ratified as a treaty, entered into force December 26, 1934 at 49 Stat 3097 as supreme law of the land under Article 6, Clause 2. Therefore, it's another violation of the Constitution. After the war between the states and its armistice, many years have passed, and all those involved on both sides are now dead. In the early 1990s, some of the people of Texas, after reviewing the Act of Congress 9 Stat 1 and House Joint Resolution 8, March 5th, 1845, 5 Stat 797, and House Joint Resolution 1, 29 December 1845, 9 Stat 108, of the U.S. Congress and other historical evidence discovered that the state of Texas is a fictitious overlay over the Texas territory, which is properly included within and rightfully belonging to the Republic of Texas, over the Republic of Texas, which was in abeyance or dormancy, and brought the Republic of Texas out of abeyance by organizing a provisional government of the Republic of Texas and peacefully held elections and have been peacefully holding elections ever since to peacefully provide common law remedies to the people of Texas. The Republic of Texas is a group of men and women on the territory properly included within and rightfully belonging to the Republic of Texas, trying to peacefully bring common law remedies to the people of Texas and the Republican form of government, because the state of Texas is a military government operating exclusively under martial law as a military dictatorship in the District of Columbia and can never be a Republican form of government.
Hey, Glenn, that could be a very, very powerful thing. To fictitious overlay
Yeah.
the Republic of Texas to bring peaceful remedies is that those words are very, those adjectives. are
Absolutely.
very powerful.
Absolutely. Even though the demandant has resigned as a senator, the demandant can say with some authority, after being involved in the Republic of Texas government for almost 20 years, that the people of the Republic of Texas would very much like to enter into a treaty of peace with the United States to bring to an end the war between the states. And I've reworded this because it's a treaty of peace isn't proper, I don't think. I think we just need to reaffirm the recognition of the Republic of Texas and give us diplomatic immunity and tell them we want to be friends. We're friends. We're not your enemy. Let's be friends. We believe it would be good for everyone, and maybe other states formerly part of the Confederate States would like to do the same. It would be very good to bring that dark chapter of our history to a final conclusion. In the year 1995, the Supreme Court of Texas dismissed case 95-1002 involving the people of the Republic of Texas for lack of jurisdiction, styled "In re the people of the Republic of Texas by and through Richard L. McLaren, their legal diplomatic representative as acting ambassador and consul general and legal affairs officer for the Territorial Land District, evidencing that they know they have no authority over the people of the Republic of Texas. The U.S. Congress and the President of the United States have acceded to the International Covenant on Civil and Political Rights, 9 June 1992, which is now the supreme law of the land as a treaty under Article 6, Clause 2, and we, the people of the Republic of Texas, have the right to self-determination and the right to determine our own political status as Texas nationals for our Republican form of government guaranteed under Article 4, Section 4, since the Pope's owned and operated United States has failed to do so. The War of Independence was fought over the imposition of martial law and found in the cause of necessities for taking up arms issued by the Continental Congress in 1775. Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the courts of common law, and instead thereof to publish and order the use and exercise of the law martial. For altering fundamentally the form of government established by charter, we saw the misery to which such despotism would reduce us. And that's issued by the Continental Congress in 1775. To supersede the course of common law, and instead thereof to publish and order the use and exercise of the law martial. And as evidenced by the organic law of the Declaration of Independence, 1776, which is a list of grievances. He's combined with others, the Pope, to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation, for transporting us beyond seas to be tried for pretended offenses, for imposing taxes on us without our consent, for depriving us in many cases of benefits of trial by jury. He's abdicated government here by declaring us out of his protection and waging war against us. And King George even signed the definitive Treaty of Peace of 1783 as Arch-Treasurer and Prince-Elector of the Holy Roman Empire, all of which evidences the true enemy being the Vatican. And these same things are happening in this case today. For all the foregoing reasons, the defendant hereby provides notice that he's challenging the constitutionality of Texas joining the Union in 1845 as a violation of this Constitution for the United States of America, Article 4, Section 3, Clause 1, which requires no new state shall be formed or erected within the jurisdiction of any other state, which is what happened, as evidenced by the Act of Congress, December 29, 1845, 9 Stat 1, and in House Joint Resolution 1, dated 29 December 1845 at 9 Stat 108, the territory properly included within or rightfully belonging to the Republic of Texas was erected into a new state be called the State of Texas, as well as the fact that the U.S. Army State of Texas Municipal Corporation and the military occupation are unconstitutional because of Article 11 of the 1933 Montevideo Convention on the Rights and Duties of States, which is supreme law of the land under Article 6, Clause 2. This court has no choice but to declare that the U.S. Army State of Texas Municipal Corporation is illegal and unconstitutional, and so is the military occupation, and Mike Blackwell is President of the Republic of Texas that has been here since 1836. And
I didn't know
that's,
you were that old.
sorry?
I didn't know you were that old,
been
Mike.
president that long.
So Glenn, what is the, if they acquiesce, how do they restructure the United States to include all the Republic of Texas that I see on this map here that goes all the way up to Cheyenne, Wyoming? I mean, what happens to all the other states?
I don't know. I don't know. That's a good question. I don't know. That's all stuff that have to be resolved. What we want to do is just right now, just what my purpose is. Mike has asked me to be Consul General for the Republic of Texas, which would mean that I'm already entitled to diplomatic immunity because I was in charge of the affairs. But clearly, executive branch officials get diplomatic immunity. So I would want a diplomatic passport. And what this I found out today that the case that got dismissed is now in the Court of Appeals. I thought, see what they did, they were playing games with me. They sent me a request for transcripts, and see, that's the thing, is the Court of Appeals has to look at stuff that was on the record, was filed into the case, and nobody's appeared. Okay, the U.S. hasn't appeared. Nobody's appeared in the case, and so I've appealed their dismissal. But this, and I've been debating about whether I would bring this as a direct action. Actually, what I was actually preparing a direct action to the Supreme Court under exclusive and 28 U.S.C. 1251, I think it is, that says that the Supreme Court has original and exclusive jurisdiction for any matter involving a state versus a state. And so we, the people of the Republic of Texas versus the state of Texas, that's a state versus a state. And I was going to sue state of New Mexico and the state of Montana because they've been attacking us repeatedly for decades. And it's war crimes. And so that's where I was going to go with it, is bring an action to the Supreme Court as an original action and take it directly. I don't have to go through the Court of Appeals. Well, now this case is in the Court of Appeals, and so I just got it today. I just barely got it today. So I have to decide whether I want to, I could still do it through the Court of Appeals with my case that's currently in the Supreme Court. There's a paragraph in there on jurisdiction. And what it says is I tell them that I'm bringing this as an action to the Supreme Court on appeal. So there's a statute that 28 U.S.C., I'm not sure what statute, but it's 28 U.S.C. something, that where you appeal from the Fifth Circuit. Okay? But I also said this is also, I'm invoking the original and exclusive jurisdiction under 28 U.S.C. 1251 because this is we the people of the Republic of Texas versus the state of Texas. That's a state versus a state. So I don't know which jurisdiction they accepted it under, but they obviously accepted the case. It's docketed and everything. And so they don't tell me which jurisdiction, how they use to justify accepting the case. But so I could, it's not that much of a stretch to bring another case directly to the Supreme Court. But now it's in the Court of Appeals. I could do it that way too. I need to give it some thought and decide how I want to proceed.
So do we get to decide then which state we're in?
Well,
if I choose the Republic of Texas, that means I don't have to acquiesce to the state of Texas for any of the things that they're imposing upon me?
Within limits. Okay, you have to understand that there's things they have that might be considered contracts. Okay, for example, aren't you a pilot?
Mm-hmm.
Well, that's clearly a contract. Okay, so
not with the state of Texas.
No, it's with the United States. Yeah, that's right. So the important thing to understand is that when you're acting in the capacity as a pilot, then you better do what they tell you to do.
Of course.
And but when you're not acting in a capacity as a pilot, then you could claim to be part of the Republic of Texas. But Ken has the same problem. He wasn't acting in the capacity as a CEO, but they just assaulted him and did all this shit to him. But I got to tell you, when I was in their jail, they gave me a court-appointed attorney. It was a lady, and I started telling her about the fact that I was a senator with the Republic of Texas, and she immediately said, "We know about Texas nationals." Okay, well, that's saying that we're not arguing about the Republic of Texas. This is not an issue involving the Republic of Texas. You see what I'm saying?
And what did that do for you?
Sorry?
And what did that do for you?
Well, so what I did, I went and sent two letters to her from jail. Okay, handwritten letters. It was motions. One of them was an affidavit of fact, which was essentially confession and avoidance. Okay, in other words, they were accusing me of organized criminal activity, of terrorism, terroristic threat because of this common law jury decision. And then plus because in the federal court case, I had said some things that somebody took as a threat. And so I said, yeah, sure, no problem. I'm a senator with the Republic of Texas. I've been involved with the Republic of Texas for 20 years. I was Speaker of the House of Representatives. I was in charge of the affairs. I'm entitled to diplomatic immunity. And we conducted a common law court, and we wanted some input from the state of Texas to see if we want them to accept our common law court cases. And so that's why they dismissed it against everybody. Because once they saw that this was really the Republic, organized criminal activity, they're saying you're a bunch of imposters. That's what they're essentially saying. You see what I'm saying? You're a bunch of imposters. But when I say that I've been involved with the Republic of Texas for 20 years, they can't say I'm an imposter anymore. And that means that everybody that was helping me with it, it's all legitimate too. They can't argue against that. They dropped everything. You see what I'm saying? But
Glenn, it's just like Jesus and the apostles. They said, "Oh, if this is real, you're coming against the wrong entity. If this is such and such,
that's right.
They're just a bunch of con artists, and it will fall on their own heads."
That's right.
If it's real, you're coming against the God of Abraham, Isaac, and
So they dropped it. But I did something else too. I also did a motion to quash the warrants. Okay, and the warrants under the Authentications Act, any document to be recognized from one state to the next state, which is Texas, New Mexico, okay? And technically, they arrested me, and I was in the Republic of Texas. I was in the Crown Plaza Hotel, which is on the east side of the Rio Grande River. So I was in the Republic of Texas, and so when they arrested me, and so I pointed that out, and it said. And I tell them I want to see the warrant, and they didn't give me the warrant, and then they gave me the warrant the next day when I was having at the arraignment, and it showed that they had arrested me at 9:00 at night, and the fax header on the warrant showed that it was faxed at 10:00 at night, which means that they didn't have the warrant when they arrested me, which means that and the warrant didn't have a court seal on it under the Authentications Act, which means it's not a lawful warrant. It's not authentic, okay? And so it was an unlawful arrest. I asked to see the warrant. They didn't give it to me. They unlawfully arrested me. And everything that precipitates from an unlawful arrest is also unlawful. And so everything falls away. And that's what I said in this motion to quash the warrant. And the warrants, there was actually 3 of them, and they had a $500,000 bond, and they had all these bond restrictions and crap, and so I think that either one of those arguments would be fatal to them. Okay, either one of those arguments. But the interesting thing is that when that lawyer came to see me, she just automatically poo-pooed the Republic of Texas. We're not talking about the Republic of Texas here. There's no dispute about Texas nationals, okay? Matter of fact, she used the term Texas nationals, and that means the Republic of Texas. You see what I'm saying?
Yeah.
And
Are you suing now for compensation for what happened to you?
well, that's what this court case was that it dismissed, and now it's in the Court of Appeals. But I was actually thinking about bringing an original action to the Supreme Court.
So, what Ken was talking about earlier in trying to do this in private versus the public,
Yeah.
are you trying to transition to private with this, or how are you going to try?
I find what Ken does to be very interesting, and it's probably appropriate under certain circumstances. They're obviously dragging him into the commercial stuff, but I try and stay away from that. Quite frankly, I try. See, look here. Fails to be dead or lost at sea, has never been dead or lost at sea, fails to be a surety for the Pope's minor estate, fails to be representing the Pope's minor estate, has never knowingly or willfully represented the Pope's minor estate. The arguments that Ken is making is the opposite of that. Okay? And so I make sure and put that stuff all over my stuff.
Interesting.
By the way, Glenn, Bonnie wants to call at 2 o'clock and talk to everybody on his phone.
She wants to call here at what? At when?
You know, on his phone, 2 o'clock.
Okay, well, I guess I better end it then, eh? I guess we're about done then.